Welcome to the International Business Law Academy. My name is TRAN and I would like to introduce my presentation on the subject Service of Process in Dispute Resolution. First, we should discuss the case study to understand about the nature of function of international law and also the right and obligation of the parties. This is the case of Bankston and versus Toyota Motor Corporation. Facts: Charles Bankston, Sir, filed suit in the U.S. District Court for the Western District of Arkansas against Toyota Motors Corporation, a Japanese corporation seeking damage resulting from an accident involving a Toyota truck. Bankston attempted to serve the process on Toyota by sending a summons and complaint by the registered mail returned in the receipt, requesting Toyota in Japan. The document were in English and it did not include the translation into Japanese, which then the receipt service was signed and returned to Bankston. Toyota filed a motion to dismiss the suit against it, claiming there had been an improper service of process. The issue was the service of process by registered mail proper. We would like to involve you guys into the discussion together to talk about the case of dispute and at the same time also giving a clarification for the theory in this case. Lynn, would you like to start us off?
Okay, maybe I would like to start us off with the service of process because a defendant generally is not subjected to personal jurisdiction of a court unless he has received service of process. Because this is a formal notification that provides the defendant with documents that give him legally sufficient notice of the lawsuit that has been filed against him.
Thank you. How about you, Ann?
I agree with Ruby. Personal jurisdiction occurs automatically if the defendant is physically present in the state where the court is located when the papers are served. Should the defendant fail to appear at the hearing after receiving adequate notice, he generally will lose the lawsuit through a default judgment.
As of I know, Article 10A of the Hague Conventions is to facilitate service abroad. So the reference to the freedom to send judicial documents by postal channels includes sending such documents for the service of process.
Ms. Glenn, what do you think?
I agree with Khan, but the second line of reasoning is that the words send judicial documents in Article 10 do not include service of process. Article 10 mainly provide a method for sending subsequent documents after service of process has been obtained by the other.
Thank you all for the discussion and also clarifying the situation. Before answering the case, I would like to review the theoretical part of the research paper. In Article 10, the Hague Service Convention, which provide in the relevant part, provided the state of destination does not object the present convention shall not interfere with the freedom to send judicial document by postal channels direct to the person aboard. Two distinct lines of Article 10's interpretation have arisen in recent years. Some of the court hold that since the purported purpose of the Hague Convention is to facilitate the service aboard, the reference to the freedom to send the judicial document by the postal channels, including the sending such document for the service of process. A second line of reasoning is that the word send judicial document in Article 10 do not include the service of process. Subscribers to this interpretation maintain the Article 10 merely provide a method for sending a subsequent document after service of process has been obtained by the means. Once again, I would like to thank you for the discussion of the theory Now I'm gonna talk about the case study. The question is, was the service of process by registered mail proper? No. At the issue of this case, the correct interpretation of Article 10, the Hawk Service Convention. A second line of reasoning is that the word send judicial document in Article 10 do not include service of process. Article 10 merely provides a method of sending subsequent document after a service of process has been obtained by other means. The second line of reasoning is more persuasive, sending a copy of summons and complaint by the registered mail to the defendant. In a foreign country, it is not a matter of service, but a process permitted by the Hague Convention. Thank you very much for the discussion, and also thank you to the International Business of Law Academy and Dr. Sir.